Welcome to the Smart Apartment Advisor Show. I'm your host, JJ Panzer. I'm on a mission to help property owners get smart about property management. Today's guest is Andrew Zacks. Andrew Zacks has exclusively practiced real estate litigation for more than 25 years, including land use litigation, challenges to local ordinances and administrative decisions, commercial and residential landlord-tenant law, rent control, property rights, and the Ellis Act. He has been named super lawyer for over 10 years straight, and he's managing shareholder of the firm Zacks, Preeminent, Patterson in San Francisco. Andrew, welcome to the show. It's a pleasure to have you.
Thank you, JJ. It's good to be here with you. Thanks for asking me.
Absolutely. It's my pleasure. So today I want to talk about two issues that I think are really important for our viewers. One is tremendously cutting edge, and that's about landlords' choice to participate in the Section 8 housing voucher program, and another about the current wisdom about dealing with service and comfort animals versus pets in your apartment building. So, Andrew, let's start out with a little bit of a primer on the Section 8 housing voucher program. Tell me about how it works and what my viewers need to know about it as far as their buildings go.
Sure. As a general matter, Section 8 is a subsidy program where the federal government will assist qualified residents and tenants with their rent. And it's implemented through block grant funds and funds that are paid to local and state agencies. So while it is the federal government that actually pays for the program, you are dealing with a local agency, either a housing authority or a countywide housing agency that's the one that actually implements the program, writes the checks, deals with the applications, and actually operates the program. In concept, it's obviously a great idea. It's helping low-income residents be able to afford to live in places like San Francisco. It's not quite that simple when it comes to practice, in my view.
So tell me a little bit about the hang-ups and the difficulties. I mean, it's certainly different from having a tenant with adequate income to apply.
Correct.
How does the program work, and how is it different from having a job or some other cash payment?
Yeah, so the main difference, in my view, is that when a property owner chooses to participate with Section 8, they basically have a third party that's involved in their relationship with their tenant, and that is the housing authority, who's in San Francisco, the agency that is assigned to deal with Section 8. And so not only does a property owner who is involved with Section 8 have to have a lease agreement with their tenant, they also have to sign a contract with the San Francisco Housing Authority as required by the Section 8 regulations.
Okay.
So that, to me, the main difference is that you're bringing a third party into the relationship, and that third party has certain rights, obligations, and duties that you otherwise would not have if you were dealing with a direct tenant.
Okay. Some
of those obligations are things that I think are potentially problematic and things that property owners should be thinking about before they decide to participate in Section 8. Some of the big problems that I see are that Section 8, the San Francisco Housing Authority, can be somewhat non-responsive when you call them.
Okay.
You're going to have them come out and inspect occasionally. I don't know that it's an annual inspection, but they do have the right to inspect. They're inspecting essentially to ensure that the property is safe, ensure that it meets the requirements as a habitable unit,
right.
And they act as essentially a supervising agency, making sure that the rent that they are paying on behalf of the tenant is going towards a safe and habitable apartment. Okay. That's one of the things that you as a property owner agree to. Also, the Section 8 regulators in San Francisco, whether it's the housing authority, get to decide how much the rent is.
Right.
So that's one thing that you give up if you decide to participate in Section 8, both the initial rent that'll be charged, which normally the landlord has a right to decide, but then of course subsequent rents are determined both by the rent control ordinance and by the housing authority.
Okay.
So to me, those are significant considerations that property owners should be bringing to bear when they decide whether or not to participate in Section 8.
Okay. Well, I've heard and been through some circumstances where having that third party, which I think a landlord should treat as the 900-pound gorilla in the room in a lot of ways, or maybe a deaf 900-pound gorilla that you can't really talk to. But even if a landlord says, I intend to operate a perfectly habitable, well-maintained building, one of the things that I've seen happen, and tell me if this has been an experience you've seen, even if the tenant is causing the damage, it becomes the landlord's responsibility to remedy that, and you can't get paid back in that circumstance.
That's right. I mean, the housing authority isn't going to look for as to whose responsibility it is when they investigate
Right.
a complaint about failure to provide habitable conditions.
Right.
They are simply not going to pay you, and at some point you'll get on a list. And even after, my understanding and experience has been, even after you've corrected the problem, it's difficult to get an inspector out to confirm that.
Right.
And even after the inspector comes out and confirms it, it's difficult to get them to start paying you again.
Right.
So when you run into, obviously things work correctly and they work as they should, Section 8 is a perfectly fine thing. The concern is when things start to break down in the landlord-tenant relationship, if the housing authority gets involved, it can be very, very difficult to get the system to work the way it's supposed to.
Okay.
And so I have never been terribly bullish about Section 8 tenancies. They also involve more complexities around terminating the tenancy when the time comes. There are special rules that apply to Section 8, both the state and federal level.
Right.
We already have a very rigorous system of regulations here locally with
Right.
our rent ordinance.
Right.
And you lay the Section 8 regulations on top of them, and you're going to be spending significant legal fees dealing with these problems when the landlord-tenant relationship becomes an issue or a problem.
If you feel like you're not adequately regulated here in San Francisco, Section 8 is a great way to get some more regulation in your life.
Absolutely.
To make sure that you are adequately supervised at many different levels. So let's move on and talk a little bit about the question of whether a landlord is compelled to participate in Section 8. Typically, when a tenant has a Section 8 voucher, they make it very clear up front when they approach me and they ask, do you accept Section 8? Tell me a little bit about how people have traditionally responded to that question and how that's changing.
So the question is very cutting edge in that there is currently litigation ongoing on this issue. California law is fairly settled on the issue, which is that under California law, a property owner has the right to elect not to participate in Section 8. And they actually are allowed to have a policy that specifically articulates that we're just not interested in taking Section 8 tenants and we're not going to. And
Right.
there's a specific appellate opinion out of the Los Angeles that actually involved Donald Sterling, the former owner of the LA Clippers. He didn't want to be Section 8 landlord. He chose not to be, and he litigated with the folks down there about his obligations to do that. And the Court of Appeal very clearly said that state law specifically does not require property owners to be Section 8 landlords or to participate in the housing assistance program, which is the contract that you sign with the housing authorities. Conversely, there are at least 4 local governments in California that have passed local ordinances that conflict with state law.
Oh, really?
And for that reason, there are actually 2 lawsuits pending, one against the city of Los Angeles, the other against the city and county of San Francisco, that argue that state law is supreme or is superior
Right.
when it comes to these issues. San Francisco has a police code provision that fairly clearly articulates that landlords cannot discriminate with respect to Section 8. This is known as source of income discrimination. That's
Right.
the technical term that we use. And San Francisco had passed this some 20 years ago, but it had laid fallow for maybe the last 15 or 20 years until a very recent case that was filed against the property manager here in San Francisco, who openly advertised what he believed to be his right, to not participate in Section 8. And San Francisco sued, and they obtained what's called a preliminary injunction, which required that he participate and consider Section 8 applicants on an equal footing with other applicants.
Right.
That injunction was appealed, is pending in I think it's the second district of the first district, second division of the California Court of Appeal. The landlord is represented by Ed Singer, who's a good lawyer here in town that actually used to work with me. And I have filed a brief on behalf of the San Francisco Apartment Association, the California Apartment Association, the San Francisco Association of Realtors, and the Small Property Owners of San Francisco Institute, who thankfully retained me to weigh in on behalf of the industry, so to speak, to argue that state law should be should rule supreme here, and that the injunction was improperly issued. Similarly, in Los Angeles, a local judge also ruled in favor of the government. Surprise, surprise, and that case is being appealed. And I hope to persuade somebody to file some what are called amicus briefs, which are friends of the court briefs, where people who have an interest in the case but are not parties can weigh in and make sure that their views are heard by the court. And I, after reviewing the city's briefs, there is a tenant amicus brief as well, as you might imagine, because the tenants are very interested in this. I just think we have the better of the law on this. I think it's fairly straightforward analysis that when the state legislature has specifically said that this law is to be superior to local laws, and they did that in this case. There's what's called an express preemption clause in the state law, that the local governments are simply not allowed to regulate in that area. And however well-intentioned it might be, and the reason for that, it's a really pretty good reason when you think about it, is that property owners, property managers, people that are involved in the real estate business should not have to face competing and different sets of rules when you cross a county line or a city line.
Cross a state line, no big deal.
Yeah, you're in another state, you're dealing business with another state. But California has certain rules that need to be statewide so that there's certainty about them and so that we don't have variances that will create problems for people. And people will get trapped and tricked.
Now, in my experience as a property manager and in the training that I've done, the teaching at the Apartment Association, we talk about the Section 8 program. We talk about how one of the things that has always been sort of a given about Section 8 is that you can't be compelled by any law to enter into a contract with the government. And so, the finer point detail was always, well, we just don't sign Section 8 contracts.
Right.
Now, it sounds to me like what's happening in some of these lawsuits is that the local governments are trying to do just that, to compel a landlord to sign those contracts by saying that setting up the barrier up front that you're going to say we don't accept Section 8 contracts is discriminatory because you are saying that because that is a source of the money that you're going to use to pay the rent, that you are discriminating against those people based on source of income. But my understanding is maybe that's not exactly true, and that there's some advice you have for our viewers about how that should be treated.
Well, source of income is actually the standard that's used both at the state level and the local level. But what's interesting is that at the state level, source of income specifically excludes subsidies that are paid by third parties.
Right. It's not income to the tenant. The tenant isn't paying it.
Correct.
So you can't use the source of income if it's coming from somebody else.
Right. And there are both state and local restrictions on source of income discrimination, but Section 8 and the Housing Authority and the obligation to sign a separate agreement with a third party are not subsumed within that.
So let's talk a little bit before we move on about when is it unlawful to discriminate based on source of income? When would a landlord clearly be wrong for a discrimination against the tenant based on the source of their income?
If a person with some type of disability, for example, and oftentimes we see folks that are suffering with HIV or AIDS, have somebody that helps them with their rent. Usually it's a nonprofit who wants to write a check. That check could sometimes be directly to the landlord, but sometimes it'll also come through the tenant. I think it's very difficult for a landlord to decline that. And I think that if you were to say, I'm not going to allow a third party to pay the rent, it doesn't involve signing a contract with that third party.
Just have to receive the check.
I think that you'd run into problems. And I think these are issues that need to be analyzed on an individual basis. But as a general rule, if you're talking about somebody who's simply looking for some help with money to pay the rent, and can't, at a particular time, can't afford to pay the rent. Now we're talking about this now after the tenancy's been created, because I think there's a difference when you're screening your tenants in the beginning. But if you're talking about an existing tenant who's run into some kind of a hard time, needs help with their rent, and they have a third party who's willing to pay it, I think it'd be very difficult to decline.
You would recommend that your client accept that accommodation?
With with a very clear proviso or letter that would be sent to whoever the third-party payer is, that we're not creating any new tenancies, that
Right.
we're not creating
You
any
can't move in.
rights, exactly,
Right.
and that this is being done as an accommodation to ensure that the rights of the tenant are being respected. I think there are some things that need to be said, and that people probably ought to talk to some kind of qualified lawyer before they actually simply say yes to something like that.
Common disclaimer, everybody. Talk to your lawyer before you do anything when you are faced with a situation you don't quite understand.
I hate saying that, but unfortunately in this town I kind of have to.
No, you need to say that. I'll say it for you. That's
Thank you.
okay.
That makes it better.
That's okay. Now, so someone calls up on the phone. They see you've got a rental listing available. They say, I'm interested in your apartment and I want to know, do you accept Section 8? What's the best response?
Well, it's a hard question to answer right now because the law is in flux, and I
Okay.
think that until we have a very clear answer, you would not be well served by saying I don't take Section 8.
Right.
I think that would be a problem.
Okay.
I think that until we have more guidance from the courts, which we hopefully we'll have within the next year, I think the answer is, well, we accept Section 8. We're willing to take a look at your application and consider it, and we will give your application the same consideration we give every application.
Right.
You should go ahead and encourage them to file an application. You should consider that application and apply the reasonable criteria that you normally do under your hopefully non-discriminatory policies that you have.
Right.
And if it turns out that person is a qualified tenant and is the most qualified tenant under your non-discriminatory practices, then I think you'd probably be well served if you want to avoid litigation. You'd be well served by probably agreeing to that. I think that in many cases there are probably other tenants that might be equally or more qualified than the tenant who's applying with the Section 8.
Keeping in mind that the Section 8 is going to pay up to 2/3 of the rent, and that Section 8 income is not income. That Section 8 money is not income. It comes from a third party, it requires a contract, and therefore a Section 8 tenant has to be able to show that they can make, in the case of my non-discriminatory screening criteria, 3 times the monthly rent and gross income. And the reality of it is that it's unlikely that somebody with a Section 8 voucher would be able to qualify and show 3 times the monthly rent, excluding that Section 8 payment that would come every month. So you are encouraged to say, we would encourage you to submit your application and we will review it with the non-discriminatory screening criteria in mind, and you'd be well served in referring the tenant to that non-discriminatory screening criteria. Now, that brings up another question.
If I may just add to that,
please.
I think one of the other things that I have observed with the Section 8 situation is that oftentimes there's a distinction between what Section 8 sees as the fair market value of the unit and what the owner might believe the fair market value to be. And if Section 8 is not paying fair market value in terms of what they're willing to pay for a particular unit, that's a perfectly reasonable reason to say no to the Section 8 applicant.
Right.
So
my asking price is $5,000 and Section 8 will only give you 4, so I'm not able to accept that.
Probably not going to work. I'll take your application, but if Section 8 isn't willing to pay what I'm asking, you're probably not going to get the apartment.
Right.
And that, I believe, would be a perfectly reasonable, non-discriminatory, lawful basis for turning away a Section 8 applicant.
That's an excellent point. Now let me ask one last question about this, and then we'll move on to comfort animals and service animals. So for me, I've got a website. We're a full-service property management company. We're advertising rentals all the time, and I've got a non-discriminatory screening criteria posted on my website, and we refer people to that all the time. But in the case of property owners who have a 3-unit building or a 5-unit building or a couple of buildings, they need to have a non-discriminatory screening criteria, but how do they disseminate that screening criteria on a regular basis?
Yeah, I don't know that they're required to disseminate it. I think it's just important that they have one.
Okay.
And I think it's important that they apply it.
Okay.
I don't think mom and pop landlord, I think is what you're talking about.
Yeah.
I don't think mom and pop landlord have any obligation to have a website. They don't have any obligation to advertise their policies. But when they receive an application, they have to have a consistent way of approaching that application, and it has to be one that's non-discriminatory. So it's probably worth it for those folks who are in that category of mom and pop, who probably oftentimes don't need to talk to lawyers, to either talk to a qualified property manager such as yourself and take a look at what your screening policies are and do their best to mimic those in some way. In many cases, they may want to hire a property manager, I will add, or they buy a couple hours of a lawyer's time. It doesn't have to be the most experienced, expensive lawyer in town, because these are pretty straightforward issues. But you come up with some you have a lawyer prepare a document for you that you can use on an individual basis when you're considering applications,
right,
to make sure that you're not running afoul of any of these laws.
And make sure that you remember what your screening criteria is from lease to lease, especially if you're going to do a lease every 2 or 3 years. You may not even remember, was it 2 times or 3 times or 4 times the monthly rent? I don't remember which one it was.
Put it in writing.
Put it in writing, keep it there. I would suggest that most mom and pop landlords in San Francisco, at least, and probably all over the Bay Area, their main source of leads and referrals is probably Craigslist. And they should probably put a little paragraph in every ad that says this is our screening criteria, just to make sure it's very clear and it's up front, and then go by it. And then it goes into lots of other issues of how to make sure that you don't have too many applications and how do you deal with those applications, which we can get to in another show. But I want to move on because I know...
I agree with everything you said too, JJ. I think it's all really good advice.
Thank you. Thank you. So let's move on and talk a little bit about service animals, comfort animals, and pets. Tell me a little bit about the difference between a service animal and a comfort animal and how that differs from pets.
Service animals require a degree of training.
Okay.
They then are considered to be there to assist a disabled person with a specific disability, or maybe not so specific a disability, but that animal is actually helping a person with some disability, and under the Americans with Disabilities Act and under state disability laws, persons pretty much have an absolute right to have a service animal. There's very little that one as a property owner could or should do,
right,
in my view,
right,
to infringe upon that. I mean, oftentimes you'll see a seeing eye dog, a dog that's there that can help somebody in a wheelchair.
Right.
Dogs, believe it or not, that as I understand it, can determine whether or not there's some kind of gas in a room that would potentially cause some kind of an allergy problem for someone. So I've seen a whole array of these. They're usually folks that have some kind of a visual impairment.
Yeah, that's the most common one.
That's the most common. And so a service dog is sort of a higher standard, and the rights of a service dog owner are certainly the most significant in terms of a tenant.
Right.
Comfort pets are a much more nebulous concept.
Yeah.
Unfortunately, they do pose significant challenges for owners who have no pet policies, because
right,
the distinction between a pet and a comfort animal is pretty small in my personal view.
Right. It's very close.
It's a very close call. I happen to be a animal lover and a pet person, so I have my own views of these things. But I do believe that my pets bring me emotional support, and I depend on them and love them every day, and they love me back. So
right,
so as a pet person, I understand that there is a certain degree of support that animals and pets provide. On the other hand, what we're seeing is essentially an internet product that's available,
right,
where one can go online, pay their $99 or maybe less. Last I checked, it was $99. It might be lower now, and they can get a little note that says that somebody is in need of a comfort animal.
Right.
And once that note is presented, and if it's done in the right way, and you have sort of an animal that's not a nuisance, and we can talk about
right,
that in a second.
Right.
The landlord is put in a very challenging position to enforce their lease.
Right. Right.
Obviously, if you don't have a pet provision in your lease, or your lease allows for pets and has pet addendums, et cetera, that are provided for, we can talk about addendums in a minute also, then this usually isn't an issue. But where you have a provision in the lease that says no dogs, no cats, no pets, someone comes to you in need of a, quote, comfort cat or dog, maybe sometimes even other animals. Have you seen other animals?
I've definitely heard of, I don't know about fish, but I've heard of other animals that qualify, hamsters and guinea pigs.
Yeah.
Pigs could very well qualify.
I think it becomes more problematic when you get beyond dogs. I think cats clearly do qualify and have qualified.
Sure.
When you get into the more obscure animals, I think it becomes probably a little easier for the landlord to say no, perhaps.
Yeah.
But I think once, what I have observed, and this, you can go into more scrutiny of this if you like, is that once presented with the note, now we're talking about how do we document this, and how do we make sure that we're not discriminating,
right?
Because the fair housing enforcement regulators, both at the public level and the private level, so there's nonprofits that are involved in this, and there are also the federal and state government that are involved in regulating these rights, take a very, very broad view of the rights of disabled persons in this area.
Right.
And there are still a lot of open questions in the law about what people can or cannot do. So unless you're interested in becoming a test case, you probably need to figure out how to accommodate a request for a comfort animal.
Right, right. And so, you know, in
And
my
just get your
practice,
experience,
in my practice of property management, I try to counsel my clients to not get so upset over the fact that their authority as the property owner has been breached, that a tenant was, you know, agreed that they weren't going to have a pet, then they brought the pet into the property.
The next
and
day.
the next day, or you know, several years later, all of a sudden there's a pet there. You're doing a routine walk through the building, and you find that there's a dog in that apartment, and the tenant's not even home. And they, you know, in the past they used to just, you know, say, well, it's a friend's animal, and you'd see it there every time, and you start to figure this out. But you know, a lot of times, well, that's my comfort animal. Okay, that's the end of the conversation of whether the animal is allowed to be there. And now you have to start focusing a little bit on what are the consequences of the animal being there in the first place. What kinds of questions can you ask? And you know, a lot of times we don't figure out about whether a tenant has a comfort animal for a long time until it becomes a nuisance. Right. Now, let's talk a little bit about dealing with that nuisance. Is it any different for dealing with a nuisance noise or aggressive, you know, breed animal, or dirt, or you know, leavings of the pet, you know, in a common area, things like that? If it's a comfort animal versus a pet, is it very different?
It's probably slightly different in my view.
Yeah.
I think that to the extent that the tenant has a right to have the pet as a result of some claimed disability,
right,
which is what we're talking about here, and the landlord has an obligation to accommodate that request in terms of a disability, that it's different than a tenant who has no disability, has no need for the pet, and their dog or cat is causing a nuisance. So I think there is a distinction there. I think it's a small one.
Right.
Because at the end of the day, I think the courts will still enforce the rights of the majority versus the rights of individuals.
Right.
And if there are other tenants or owners whose rights in the property are being interfered with in an unreasonable way.
Right.
Reasonable is really what we're talking about here.
Right.
Then I think that owner has rights under both the rent control law and the disability laws to warn the tenant, and warning is important in my view, and there has to be a paper trail set up here. But if the tenant doesn't comply with those warnings and doesn't respond to them favorably, then I think it's grounds for eviction under the rent control ordinance.
Right.
And you know, they're not easy cases. They're never easy cases.
Right.
Even when you're not talking about a comfort pet, nuisance cases are some of the most challenging that we have.
Yeah.
And we can talk about that if that's something.
Even if there aren't pets and disabilities involved, nuisance
yeah.
cases are difficult.
They're very, very hard.
And you know, one thing I try to counsel my clients on is that, you know, eviction is the lever that you must pull in a circumstance where you're having a nuisance, regardless of whether it's a pet or not. And you have to be going forward with an eviction case, but you have to get out of your mind the thought that you are absolutely going to get the tenant out of the building as a result of your nuisance case. You have to be driving to solve the nuisance, to solve the problem. A lot of times the best you can get is a stipulation from the tenant.
And actually, it's a really great point you're bringing up, because I think that there are actually other alternatives that we have actually explored in this office, which are, you may think about perhaps trying to get what's called an injunction.
Right.
And we've actually gotten them in pet cases where people didn't control their pets.
Right.
And we had other tenants in the building complaining about the fact that the pets were not being controlled. And we had the tenant saying, well, I need this pet. This is for my well-being. This is my comfort animal, my service animal, whatever it might be. And there were things that the tenant could be doing to control the animal, but they weren't, and they wouldn't in response to requests. So recent case that it was not my case. My partner Scott Friedman handled this on behalf of a very good client of ours. Filed a lawsuit against the tenant, basically laying this out for the judge, saying that we were caught between these two requirements that we have to our other occupants and our obligations to a tenant who has a disability and is claiming a disability right. And we asked the court to issue a very specific injunction in which the pet owner or the tenant would be required to control the pet in very specific ways. Right. And that was granted.
There you go.
Yeah. So your point about not getting hung up on eviction, listen, evictions are hard. They cost a lot of money in this town.
Right.
There are a lot of resources available to tenants to fight them.
Right.
And so unless you just are absolutely 100% committed and you're ready to take a lot of risk and chances,
right.
You need to get your arms around the fact that that may not be what happens at the end.
At the end, you fight through an eviction case. You can be right and still lose. Yeah. You can end up with the eviction and have lost more in the process. Or not get the eviction and still lose more than you cared to venture in the beginning. And so, you're trying to solve a nuisance problem when it comes to pets. I've had issues with aggressive breed animals that are not controlled in buildings, and a tenant who claimed that animal was an accommodation that needed to be made, and we were able to get a stipulation from the tenant that that animal would not be back in the property because that animal was a problem. It was not saying you're not allowed to have a comfort animal. It's that animal is a problem.
And that is a great outcome for your client.
It is.
Because we had a similar case in this office.
Mm-hmm.
They went to trial.
Oh, boy.
Went to jury. And we had complaining tenants about pit bull. Their client, the tenant, claiming that they had a right to the pit bull because it was a comfort animal, and they had proof of that. They had therapists and psychiatrists who were prepared to come to court. We had a very sophisticated jury, and jury ruled in favor of the tenant. Said, we're not going to require them to get rid of the dog, and we're sort of unrelated to the actual pet itself.
Right.
It more had to do with the fact that the owner had waited too long to bring this to the attention of the court, bring this to the attention of the tenant, and found that the owner had waived any rights that they had under their lease, because there was a lease that said no nuisance activity.
Right.
And in that case, that really highlights your point, which is if you can get something less than eviction, that's still part of your obligation as a landlord to pursue.
Right, and I think one of the things that's really important about that point is that your client didn't lose the case based on the fact that they didn't have the right to, the absolute right to enforce that. They lost the case based on the fact that they waited too long to enforce those rights.
Yeah.
So if they'd been more diligent in the beginning, recognizing it's a problem, I've got an animal that's causing a nuisance for other people in the building, and begin the letter writing campaign with a potential eviction lawsuit as the outcome. Doing it sooner rather than later is the thing that prevents you as a landlord from being exposed to this kind of risk and liability.
I agree 100%, JJ, and I also would say that in the case where the jury ruled in favor of the tenant, at least the landlord is able to say, if there's a problem down the road and that pit bull causes a problem for one of the other tenants, hey, I did everything I reasonably could.
Right.
So they met their standard of care by attempting to evict. And just one of those situations where there's nothing they can do in this town.
Right.
And I do want to emphasize, this is a very difficult town with our courts. I think our judges do the best they can, and I think that they work hard to try and be fair. But the reality is that we're in a tenants town. The tenants are the voters. The judges are elected, and we probably have as hostile, difficult of an environment with respect to the legal system than just about anywhere, maybe other than Santa Monica or Berkeley.
Right. But it's important to be proactive in responding to these sorts of claims, see how important they are from the very beginning, and consult your attorney. Don't be too afraid of getting billed. Ask even the simplest questions to make sure that you can make sure that anything that could be uncovered as a part of the process is known by your practitioner of the law in advance, and they can inform you of the best things to do to take care of it. So don't ignore.
And not doing that is only going to end up costing you more and causing you more problems in the end.
Yeah. So let's wrap up. I want to talk a little bit about sort of the difference in the way the landlord can address this problem in a building where they have a no pets policy versus a landlord that opens their arms willingly to pets. If you allow pets in your building, you get to do certain things as a part of that. Let's talk a little bit about what rights you have in that circumstance.
Yeah, as a pet lover, and I'm very aware those things were much on my sleeve. I enjoy animals and have dogs and cats and have my entire life. To me, it might be, given the fact that there's very little you can do when somebody seeks a comfort animal, there may be good reasons why you would want to not have an anti-pet policy in your lease and in your rules. Would you agree with that?
I think so, absolutely.
And one of the things that allows is that people don't need to create a reason to have a pet. They still might, but they don't need to create that, and they know that they can have a pet, and you can then create certain rules and regulations that apply to that pet in the form of a lease addendum.
Right.
So I'm sure that you counsel people about.
Yes, absolutely. And my feeling has been a lot this has been developing over the past 5 to 10 years, really, that allowing pets is a good way to be able to start the relationship with your tenant off right. It makes it more easy to have a good relationship from the beginning when you're allowing them the opportunity to do something at the very beginning, and you're making it clear. There will be a document that is signed that is comprehensive, that discusses all the ways that you need to regulate the behavior of this animal that you're going to have living with you, and that failure to do so is a grounds for an eviction lawsuit, and you have more hooks into the tenant at that point for violation of that agreement, as opposed to saying, I said no pets, you brought a pet, that's the one reason why I'm going to try to evict you. That reason doesn't really exist anymore.
That's right. I think you've hit it exactly on the head. And what I would say is, if you don't have a policy like allowing pets, then the tenant can get himself a comfort pet letter, and you're not allowed to ask for an addendum in that circumstance. So now you've compromised your rights under your lease, under your ability to get a lease, by not having a very clear and open pet policy.
Right. And then, keep in mind, you can also ask for a slightly larger deposit as a part of allowing a pet. Remember that your limit is 2 times the monthly rent in deposit for an unfurnished unit, 3 times for a furnished unit. But my standard security deposit is a month and a half worth of rent. You can add another 25% or 10% or however much you think is reasonable up to that limit to accommodate for the pet. In a lot of circumstances, landlords try to ask for extra rent in exchange for having a pet. What do you think about that?
Well, I mean, it's a function of the market, right? I
Right.
mean, and so if I assume that there is some degree of a distinction between a pet building and a no pet building in terms
Right.
of what the value of the unit is. I would say if the market does accommodate higher rents by allowing pets, then there's nothing wrong with
Right.
charging more, but you can't be discriminating on it. You have to be
Right.
consistent on it.
Well, and
So-
keep in mind, if you try to do that, you'll end up with somebody who says, well, mine's a comfort animal, and therefore you can't charge me the extra rent.
So I don't think you want to charge extra for the pet. You just simply are going to have higher rents in a building that allows for pets.
I think that's probably the case. Well, okay, that sounds like a really great list of topics, and that's a good place to end. So I want to thank you very much for joining me today. It's been a pleasure
Nice to
having
see
you.
again.
Thank you for your wisdom.
We're neighbors,
Indeed,
Yeah.
yes, that's right. Andrew lives up the street from my office, so
years.
we're in the neighborhood all the time. But that's it for today, everybody. Thank you very much. I'm JJ Panzer, your smart apartment advisor, reminding you that even though life is short, it pays to take the long view. Take care, everybody.
Thank you, Jake.